Would you like to reserve any time?
Yes, please. 5 minutes for rebuttal.
Yes, sir.
May it please the court, Nicholas Consalvo on behalf of appellant Michael McKinley. Mr. McKinley was denied a fair trial in this case for a number of reasons, and we request this court reverse and remand for a new trial. The first issue I'd like to address is the issue of the denied juror cause challenge. In this case, the trial court erred in denying McKinley's cause challenge of a prospective juror, forcing McKinley to use a peremptory challenge on a juror who should have been excluded for cause. The totality of the remarks by the prospective juror, Juror Jones, were sufficient to establish reasonable doubt as to her impartiality. The juror was asked to discuss her disclosed history of a prior personal injury action and injuries resulting from that a automobile accident. She discussed her negative emotions and opinions regarding that experience. She explained that she had settled the case before it went to trial, but that she was ultimately not satisfied with the outcome of the settlement.
Mr. Sir, what I see in the record and quote from the record is, I don't think I understood the amount of pain that you're in years past once you come to some sort of a resolution or result. Where in the record does she answer the question with something negative about the legal system to indicate that she's biased one way or another?
It was her negative experience with the overall settlement. So the fact that it didn't go to trial and that it wasn't directly related to experience at trial was not the issue here. This was directly concerning her negative emotions regarding and negative personal experience about how she interpreted her settlement for future medical expenses and future pain and suffering and things like that. Two issues that were front and center in this case. And she also described that she had suffered injuries that were similar to the same exact injuries that the plaintiff had suffered in this case and was seeking damages for. She underwent the same type of medical treatment with epidural steroid injections and medical branch blocks. She talked about that she was still undergoing pain management treatment and taking pain meds to manage her pain. So it was the totality of her remarks
But when counsel below for the defense asked, can you focus in on the evidence the law presented and be able to render a verdict? Do you feel pretty comfortable you can do that? She said yes. Thereafter, he asked the entire venire, does anyone disagree with Mrs. Jones' feelings on that? And no one did. So where during the voir dire did the defense inquire as to her bias toward either party or toward the system, or she couldn't be fair to either side?
Your Honor, that comment about whether she could render a verdict, that was in response to a question about and comments about the adversarial system. And she was asked, can you render a verdict in light of any offensive or contentious actions on behalf of the attorneys? Will you be able to not hold that against the parties? So that was unrelated to the bias that we're pointing out here regarding her comments about her experience with the settlement, with her negative experience about the amount of future pain and suffering that she was able to recover, the relationship that the same injuries and medical treatment that were at issue in this case.
Mr. Consalvo, I tell you what, if the test for striking someone for cause is unpleasant experience with the legal system, I submit that half the people probably on this call would be stricken. I mean, it sounds like a perfect basis for you to use your peremptory. But I'm frankly, I don't see how this goes to her, her not being able to render a fair verdict.
Sure. The distinction we make here is the case law talks about the differences between generalized preconceived opinions about litigation, which I think Your Honor's
What
referring
did she,
to. And
did she express an opinion that says, I don't think litigation is fair, or I don't think it's fair to plaintiffs, or I don't think it's, I mean, I didn't get any of that. She just had her own personal experience. And,
no, Your Honor,
and perhaps later wish she hadn't settled for what she settled for, basically.
No, Your Honor, and we're saying that it was not a generalized preconceived opinion about litigation. This was the prejudice here, and the reason for cause was where there's opinion stemming from a negative personal experience, as opposed to just saying, I have a overall preconceived negative opinion about the litigation. That's where we believe that the basis for cause was.
Well, as I read the voir dire, there were 2 or 3 jurors that were clear. One said, I'm not the man for this case. One has suffered the loss of a loved one in an auto accident. One had already been in an auto accident, just said, I don't believe in this. That's pretty clear. And both sides inquired of him. I'm trying to wonder why. I've done this hundreds of times, but the defense, once you hear something like that, you probe in to see, hey, is that experience going to affect your ability to be fair and impartial in this case? She was never asked that. I understand him talking about the adversarial nature of trial and all that, but he never drilled in and said, Ms. Jones, you have relayed to us some problems with your prior lawsuit and you still have lingering pain. Can you be fair in this case? That was never asked. And the judge said, my notes are clear. She never said anything that would indicate she couldn't be fair. So where else is it that I can find in here that would support your argument?
Your Honor, it's the basis for the cause challenge was really that discussion of her prior negative experience. Understandably, there was no direct question about whether that affects your ability to be impartial, but that was the only comment by either side that was asked of her, and that was the last thing that was asked was this issue about that raised a question about her impartiality, and that's where the case law generally says that the exclusion based on cause should be weighed in favor of excluding the juror when there's any question about the impartiality. With that, Your Honor, I'll move on to the next issue. The next issue concerns the trial court's abuse of discretion in this case in precluding 2 of McKinley's expert witnesses from testifying regarding the reasonableness of the medical bills in this case. Both experts satisfied the requirements under Daubert to test.
On this question with you, on this issue with you, Mr. Consalvo, your friend on the other side essentially argued, one of the points he makes is that this is a non-issue because the plaintiff ultimately only recovered 120 for past medicals, and that figure doesn't include any portion or category of damages about which you're now complaining. And if that's so, why are we talking about this?
Your Honor, there's 2 reasons why that's a incorrect position by my opposing counsel here. The first is that to the extent that that would be a harmless error analysis, that is the plaintiff's burden in this case, the appellee's burden in this case, to show that there's no reasonable probability that the error contributed to the verdict, and that's under special. And again, that says error contributed to the verdict, not to the final judgment after set-offs, after apportionment of liability. It's whether this was contributed to the amount that the jury awarded in the verdict. The other issue is that this was relevant to both the testimony about the reasonableness of medical bills was relevant to both past and future medicals. The expert disclosure for Dr. Cutler and specifically directly indicated that he would be testifying as to the reasonableness of both past and future medicals. The future medical bills were based on a life care plan expert testimony where he based the amounts in the life care plan off of the recommendations and the billing of the treating providers, the same treating providers who had provided the past medical bills that were at issue in this case.
Well, let me ask you a question about, how do you pronounce it? Is it Zide?
ZD, I believe.
Zidi, thank you. Well, you would agree with me, a CPT code does not demonstrate whether a particular medical treatment is medically necessary or reasonable, correct? The CPT code is what they charge and what they place in for payment, correct?
That's correct, Your
And
Honor.
Zidi is well qualified to do that, and the court found that, and ultimately he testified that the treaters upcoded. They improperly coded for more expensive procedures and coded for a service that's not even documented, unlisted service several times. He found double coding. He found a code, improper code for cerebral palsy. Spinal kinetics were not properly coded, and coding for manual therapy multiple times was incorrect and invalid. So basically the import of his testimony is they overbilled and they overcharged. So how is that an abuse of discretion? It seems to me that the defense wanted him to testify to the jury as a orthopedic surgeon. I never would have done this and I never would have charged this, rather than sticking to the coding issue.
Your Honor, as both doctors were intended to testify as to coding and billing, and the two issues go hand in hand. The way that they evaluate these cases is they review the medical records. They determine, as Your Honor said, whether the procedures documented in the medical records were actually coded for and billed to the client. But and as Dr. Zidi pointed out, there were several instances of that. But for example, where there's instances where there was a correct code, where there was a correct CPT code for a billing entry, those billing entries were also overinflated and overbilled. And so the trial court.
But he admitted that he did not know the usual and customary charge for Tampa Bay, because you would agree with me, if you're in Miami, where one of your offices is, it's quite different, probably more, as opposed to your Jacksonville office, which may be less. I don't know, but he didn't know.
Your Honor, he didn't have direct person. The issue here was that the court conflated the three distinct Daubert factors: the qualification, reliability, and helpfulness prongs. When asked whether he had personal knowledge of the local rates, that was in regard to whether he had personal knowledge of how the provider at issue here, what the overhead was of the provider's office, what was the exact number of surgeons in the area. And then the trial court here conflated the issue by excluding him based on qualification, to say he had no experience or insufficient experience and training to render these opinions. So
let me ask you this: if you're saying that that was excluded from Zidi's testimony, you would agree that Cutler, the neurosurgeon, was allowed to testify. First of all, he didn't need this treatment. He wasn't injured. He had no permanent injury. I wouldn't have done this treatment, and he needs no future treatment, correct?
That was the testimony of Dr.
That was the testimony
causation.
before the jury.
As the
Now,
causation.
now, Cutler said that I'm the billing master. I do this, that, and the other thing, but he didn't get real particular as to what empirical evidence. He just he selects a percentile. You know, he said that they charged 80,000 for surgery and I would have charged 8. That's just that's pure personal opinion, is it not?
Your Honor, it's an expert opinion based on reliable methodology. He's using his personal experience as what he would testify to, and what he would have charged for these rates and these procedures. He's considering, in conjunction with that, his use of the CPT codes, his use of the fee booklet that he used to determine the percentile ranges. So all of that together was where he is creating this opinion. And the other issue with Dr. Cutler here is that the trial court didn't actually perform any Daubert analysis at all for Dr.
Well,
Cutler. He simply
As I can see in the record, you didn't ask for one. The defense never asked for Daubert, did they?
Your Honor, we objected to this to plaintiffs, or excuse me, we opposed plaintiffs' objection on the grounds that they had missed any deadline to seek to exclude the expert, Mr. Cutler, on a Daubert challenge. They had indicated an objection, but it's the plaintiff's burden if they're seeking to exclude his testimony, that they have to set forth evidence as to why he would not be qualified, and ask to perform a Daubert hearing in order to establish that the methodology was improper, that he was unqualified. But here, none of that happened. They initially made a Daubert objection at the deposition, and then in trial, when they raised the objection, they said, well, irregardless of Daubert, we have to apply the evidence code here. And testimony is hearsay because he's utilizing this medical fee directory book in formulating his opinions.
All right, you're into your rebuttal time. You can use it as you wish. I just wanted to alert you, sir.
I just briefly say, and the issue here, Your Honor, is that the evidence code allows for an expert to testify as to evidence that may not be facts and data that may not be admissible into evidence, and that was what was at issue here. Dr. Ziti utilized this as a well accepted methodology to establish his opinions as to the reasonableness of the fees. And with that, Your Honor, I'll reserve the rest of my time for rebuttal.
All right, sir, you have 4 minutes. Good morning, Mr. Sales.
Good morning, Your Honor, Your Honors. Thank you. I'll take the issues, the first 2 issues that are raised in the brief and the issues argued today in the order in which they were raised. On the first question, and for both of my responses to both points 1 and 2 in the briefing of the appellant, I'd like to sort of give the court a little bit of an overall perspective of what is sort of lurking if you interpret the record, I think, fairly the way that it shows. What happened with respect to the jury issue is that the prospective juror Jones didn't say anything that would give grounds for cause. And I agree with Your Honor, Judge Sleet, that typically what happens, and we've all been there, you try to make a decision, and my read on it, if it matters to the court, because cause wasn't shown, but my read on it is there might have been something there, and then the lawyers trying the case have to make a decision. Do we push this juror? Do we want to hear the response, or do we hope that the trial judge will bite on something that sounds, and when I first read the brief, the defendant's brief, I was, I got to look into that. But here, the trial judge, it's one of those judges who keeps a chart, takes notes, and if you actually read the comments that she makes, she looks into the margin, I think, and says, I've got nothing. And so it's because there was nothing. And counsel, Mr. Consalvo's tried to sort of retool a little bit the question and answer that Judge Sleet, Your Honor, mentioned about the overall, did the juror bite on anything? Because counsel, I submit, sort of tried to slide that in sideways. And he's right. There were multiple questions about the process, and counsel tries to slide in the question. It's at 48, 40, 54. Can you focus on the evidence, the law presented, and be able to render a verdict? Answer, yes. But the real point is here, and from the bird's eye perspective, again, following up with what respect to one of y'all said, 9 jurors, when this conversation started, and that's at 48:10 of the record, indicated they had some kind of spine injury. 9 members of the panel. So many, in fact, the plaintiff's counsel said, holy moly, it's a lot. And what's happened, I think is, and this is really, if you look at, for example, Embleton versus Sonatus, everybody's familiar with the Rawlings case. Rawlings is cited there at 993 Southern 2nd, 596. And what the defendant's doing here is trying to set up what Rawlings refers to as an impossible standard. If they're right, that's saying I was hurt, I'm sad that it didn't turn out good, and that makes the juror, the lawyer worried about the juror, we'll never get a jury, and it's hard enough to get people to sit anyway. So the question is, was there reasonable doubt? And given the deference that the court is obliged to show most respectfully to the trial judge with respect to her observations, which, and we don't usually have this, they're stated on the record. There's no grounds, most respectfully. Twice, the juror said she could do what we expect that she should be able to do to be fair and impartial. And there's no grounds for reversal there. Similarly, on the medical bill issue, I'll get to the harmless error point in a moment, because this is a case which I call this harmless in fact, as opposed to something where people have to argue about what could have happened, what might have happened, which after special causes all kinds of problems for litigants now in civil cases. But if you take sort of the bird's eye view, what really happened here is that Dr. Zaidi's testimony was going to be challenged. There was a Daubert motion against him. We raised all kinds of stuff. The geography one, the geographic variances of which is the most important, and I'll speak just briefly about that in a moment. And then they were going to have to call Dr. Cutler by video deposition. They didn't know what was going to happen with respect to the Daubert motion on Zaidi. And they hadn't really, I think they conceded it at trial. It's a little bit ambiguous, but they hadn't really listed Cutler as a billing expert, different from a coding expert. And so when they did his video deposition, they tried, and I'm not saying counsel did anything wrong, I might have done exactly the same thing, but they tried to sort of slide some billing testimony in there too, in addition to what he had been prepared to testify to. And if you look at the testimony that we've referred to in the brief, it pretty clearly indicates that he wasn't actually prepared on this question, because he says, if I was gonna, look this up, I would probably find X, Y, Z. And he refers to the book. I think I know what book he's referring to, but he doesn't say that he's actually even referring to the particular book that I think he's referring to, which is sometimes called the PFR. I think it refers to physician's fee reference. There just wasn't a basis for him to express that. So what happened is they come to trial, we come to trial, and they want to use the video preservation deposition. They admitted in the trial court, this is cited in our brief, the record citation, that we timely objected to this billing testimony because, as I said, it was sort of arguable whether they had listed him for that purpose. But it's really sort of a sideshow, I think, because the trial judge's findings that it was hearsay, which on the face of things seems reasonable, and the abuse of discretion standard was justified, and that it wasn't based on a reliable method. On that, both parties cite this, and now the Supreme Court has told us, which always I find interesting. Same with the summary judgment. Judges, you're supposed to look at all the federal authorities and apply Daubert. So now we have this very unusual, although we've had evidentiary rulings on experts for years. Now we all cite federal cases about what to do with respect to the calling of experts, which is fine. So both parties rely on this Eastern District of Louisiana case called Collins 470 F sub 3rd. And what they say is the methodology that is inferred but not obvious from the record is one that's supported by this decision. And answering your question about geographic modification, because that witness did allow for the consideration of the PFR. And it says she, referring to the expert whose name was Mikalski, this is at 604, used a geographic modifier to arrive at the local value, for these services in the New Orleans area. Both parties cite this. She then compared plaintiff's medical bills to the local value in the New Orleans area. Her methodology was peer reviewed by Gerard Anderson, and it goes on. That's what they say, that the methodology that they're referring to is the same as this, and therefore, quote unquote, easily passes the reliability standard. They didn't do that. And I know Dr. Zaidi, by the way, very well. I'm from West Palm Beach. He's from West Palm Beach. Cross-examined him way back when I was with the Searcy firm. And the reason he doesn't include any geographic consideration, he actually says it in his deposition. And this is at page 1608 of the record. It's depo pages 66 and 67. And his reasons that he doesn't consider geographic modifier. Now, mind you, these databases, and this is in the record, have geographic modification capacity. You can look at geographic variations, but he doesn't do it. The reason he gives is it's statistically insignificant, which he never explains. And the trial court read all this, by the way, according to the record. It would be based on a particular CPT code. I don't know what that means. And 3, it would not be accessible, which doesn't seem to be supported by the record for the reasons that I just gave. It would be anecdotal. Well, that's sort of the point about the hearsay. And finally, it may be antitrust. And what he goes on to explain is he refuses to look at local rates because, if I understand his testimony, if doctors look at what each other charge, they could be accused of price fixing, colluding to fix prices. It's a little bit out there, but the point is it sort of corroborates what the judge said, which they don't challenge, that he didn't know what the local rates were. So how could there be an abuse of discretion there with respect to Dr. Zaidi? On the harmless error point and getting to the issue, again, I call this harmless in fact, because we know, and it's worth, if there's any doubt about it, it's worth taking a look at. We know, in fact, that there was no recovery in this case for past medical expenses. And by the way, they did not, in their initial brief, say that that was a barometer for future medical expenses. Here's the first sentence in point 2 of their brief at 38. The trial court abused its discretion, excluding Dr. Zaidi and Dr. Cutler's opinions as to the reasonableness of the medical bills. And if you go on and read the rest of the brief, they're clearly talking about the bills that have been rendered. There's no indication or discussion that the treatment's even going to be with all the same folks. And in fact, some of the treatment that's predicted and forecast in the future is not even going to be with these same folks. But their brief is about that, past medical bills. They did claim in the trial court that there was some way of having that be a barometer of future pain and suffering. They abandoned that on appeal. But getting back to the issue of harmlessness, we know it's what I call harmless in fact, because what the trial court did in this case was take their recommendation. This is, again, it's worth taking a look at, which is at page 4527. They claim that the set-off is $252,000 and change. And I don't agree with their calculations necessarily because they applied comparative fault twice. They say 60% of the total set-offs is $151,000, 4527 on the record. So according to them, what they told the trial court was the collateral source payments paid or available in this case exceeded the amount that the jury gave to the claimant for the same category of damages about which they're complaining. Then if you go to page 4531, they tell the judge, enter a judgment in one of 2 amounts, both of which have as a line item described 4531 past medical expenses 0, $1.935 million. And that's the amount that their suggestion that we oppose that for reasons that don't matter. That's the amount of the final judgment in this case. They told the court, don't give this plaintiff a net recovery of any past medical expenses. And the trial court agreed. And that's what the judgment is. So that's why I say it's harmless in fact. And I think it's clever, and I don't mean that derisively, for counsel to say, well, the question is, did it affect the verdict? Yes. The question is, did it affect the verdict? And it may certainly have affected the verdict for past medical expenses, but the court is still obliged to consider whether there's any net consequence, adverse consequence, because this is a court of error, and the court of error has to consider only errors that matter. And as a matter of law, it did not make any difference to this defendant. So for those reasons, and unless the court has any on the subsidiary issues that they've raised, unless the court has any further questions, I won't use the rest of the time I have remaining.
Mr. Gonsalvo, I have 4 minutes, sir.
Thank you, Your Honor. Your Honor, to address one of your original questions and plaintiff's contention that this was harmless and that this had no effect on the case, and whether the coding testimony alleviated this issue, it absolutely did not. The ruling here precluded McKinley from presenting any evidence to rebut the reasonableness of the claim medical bills. This was directly addressed in plaintiff's improper closing argument, where they repeatedly told the jury that the evidence of their past and future medical bills was unimpeached, was unchallenged. So to say that, well, there was discussion of the improper coding, yes, but there was also properly coded medical bills that were equally inflated. And the exclusion of this testimony was improper. The rejection of an expert testimony under Daubert is the exclusion, not the rule. And it's particularly relevant where the exclusion goes to a single issue or a single witness that is a key issue in their defense of the case. And that's exactly what happened here. It's evidenced simply by the fact that that's what plaintiff argued in his closing argument, that, oh, see, they didn't present any evidence to contest the reasonableness of the rates. And that was a misleading and improper argument. It's improper for a lawyer and a party who has successfully excluded evidence or excluded testimony to then seek an advantage before the jury to say, well, see, there was no evidence presented on this issue, so you should award us exactly what we requested. And the knowledge of local rates, again, that's not a requirement to determine whether an expert has sufficient qualifications. That's the conflation of the Daubert prongs that's at issue here. There is no suggestion that that's a requirement as a qualification. That the case law cited by plaintiffs in this appeal discuss how that's relevant to helpfulness and the distinction between when a medical versus non-medical expert testifies as to the helpfulness. And in those cases, the exact example that the courts gave when they excluded a non-medical coding expert who wanted to testify as to billing was to say, well, the solution for you is to bring in a treating physician who can come here and say, this is what I would charge. That's the exact way that a plaintiff is allowed to rebut the testimony of and the reasonableness of the medical bills, is to either present a medical billing or coding expert or to bring in a physician who would say, this is what I would charge for the rates. And that was also evident in Dr. Cutler's proffered testimony, where he says at times he's relying on the values he gets from the books, and at other times he just directly says, this is what I charge. I have this exact appointment tomorrow to perform this procedure, and this is what I would charge for that rate. And that's the proper way to rebut this testimony, is to present a doctor that just so happens in this case to also be a medical billing or coding certified expert, who can then say, if I would have treated this person, this is what I would have done. And this is what the charges would have been. This is what's customarily and reasonable for this specific procedure. And unless the court has any further questions, for those reasons, we respectfully request that this court reverse and remand for a new trial. Thank you.
Thank you both. Well briefed, well argued. Before I let you go, I'll say on behalf of my colleagues, from litigation all the way through trial up to this moment, it was very professional and civil. And we like to see that. The lawyers conducted themselves professionally. It was civil. It was a hard fought battle. We appreciate that. Have a good day.
Thank you, Your
Thank
Honor.
you, Your Honor.
Excuse.
You're excused.
Thank you.